Hello, my name is Brittany Brown, and today I am presenting on the Carol Cutting versus Down East Orthopedic Associates case from the state of Maine. This case is still in process and presents key concepts we learned about in healthcare law and ethics. The case was of particular interest to me due to its proximity to me in Maine, and it covers concepts we learned about informed consent, as well as claims that Carol Cutting's Americans with Disabilities Act rights were violated based on how she was treated by her doctor when seeking surgery to provide relief to an injured shoulder. Both are closely related to patient rights that need to be adhered to in healthcare. According to the Grady text in the course, through the process of obtaining informed consent, a medical provider must include disclosure, gauge a patient's comprehension, and finally, gain a patient's voluntary choice and authorization to provide care. Cutting indicated she was not informed that her shoulder injury would not be corrected because the doctor thought the repair would be guaranteed to fail after learning that she had a Tourette's disability and a potential rotator cuff tear. This suggests that some of her rights under the ADA were not followed. The ADA states that what is important is a person with a disability receives medical services equal to those received by a person without a disability. Understanding what assistance, if any, is needed and how to provide it will go a long way toward providing safe and accessible healthcare for people with mobility disabilities. So looking at the case summary, Carol Cutting is suing Down East Orthopedic Associates, and in June of 2013, she met with a Down East doctor to discuss shoulder pain. She informed the physician that she has Tourette's and has vocal and motor tics that occasionally include arm movements and pointing. Upon sharing this information with the physician, it's reported that he physically distanced himself from Cutting in the treatment room to avoid being hit. In the process of gaining informed consent to treat Cutting's shoulder pain with surgery, the Down East physician did not discuss how Tourette's might impact the surgery and that if a rotator cuff tear was found, it would not be repaired. A few months later, in November of 2013, the surgery was performed and a rotator cuff was found, but not repaired. Cutting continued to have shoulder pain and had consequent surgeries in 2015 and 2018. In November of 2016, Cutting filed a claim against Down East claiming negligence to obtain informed consent, medical malpractice for failure to obtain an updated MRI and failure to repair the rotator cuff, and indicated the doctor's treatment violated her Americans with Disabilities Act rights. Her ADA claim ties in with the Maine Human Rights Act and alleged that her doctor treated her disrespectfully, that he did not disclose that his approach to surgery would be different than an ordinary patient, and that he refused to repair her rotator cuff, all due to her Tourette's disability. Looking forward to today, federal courts have turned down Cutting's claims related to the Americans with Disabilities Act and medical malpractice. Her case in Maine is still currently taking place, and no final judgments have been made about the failure to obtain informed consent from the Down East physician. There are a few pieces to the current status of the legal holding of Cutting versus Down East. While the federal case relating to ADA and malpractice claims has been dismissed, the state of Maine has yet to reach a judgment on the informed consent claims. Down East filed with the Maine Supreme Judicial Court to dismiss Cutting's claims based on the fact that they had been previously dismissed in a federal court. In early 2021, the Maine Supreme Judicial Court denied the need to invoke judicial economy exception. Judicial economy provides the opportunity for a case to be limited to the resources a court has that result in a refusal to make a decision on a case. So essentially, because of limited resources, Down East wanted to have the case dismissed. Additionally, there's a question in the main case about the need to apply res judicata. Res judicata indicates that once a case is ruled on, it cannot be further pursued. Since the facts in the case can't be separated from one another, the facts previously used in the federal case can be used in the state of Maine informed consent case, despite the ADA and malpractice claims previously being dismissed. Reflecting on the ruling of the case, I do find myself siding with Carol Cutting for a few reasons. When we consider previous cases related to informed consent, such as the historic Salgo versus Leland Stanford Jr. University Board of Trustees, Martin Salgo was not informed of all potential outcomes of his proposed treatment. Similarly, Carol Cutting was not informed by her care provider of any alternate plans if the doctor found a tear in her rotator cuff, which he considered to be a repair that would result in failure. For the medical malpractice suit, which has already been ruled on and dismissed in federal courts, I think that Cutting could have been more successful on a state level initially rather than on the federal level. Salgo versus Stanford could serve as a legal holding that the unsuccessful surgery that Cutting had was malpractice since appropriate informed consent was not gathered. And that's where the concept res ipsa loquitur, meaning the thing speaks for itself, comes into play. The ADA case is where I found myself feeling sympathetic and siding the most with Cutting, but I also recognize that this would be the most difficult to be ruled in favor of since it's established at a federal level. The ADA clearly states a goal to make medical services equal to all, and it would be easy to argue that her medical care was not equal as she received a different treatment from a typical patient. And looping back to the informed consent claims, she was not only treated different, but she was treated disrespectfully by her healthcare provider when he learned of her condition, that she's likely been made fun of throughout her life. My thoughts on the ruling reflection tie in with health injustices that I found, and I thought that the informed consent and ADA were woven together in health injustices. The interaction Carol Cutting had with her healthcare provider indicates that she was treated poorly. Patients seeking medical care look to physicians to make them feel better, but her provider's response and reaction to distance himself physically from her in the treatment room and then treat her poorly resulted in emotional damage and an understanding that her rights under the ADA were violated. Later on, Cutting was able to receive the originally planned rotator cuff repair with another physician. Since her provider at Down East thought that the rotator cuff repair was a guaranteed fail due to her Tourette's condition, it's difficult to understand why the surgery was done without explicitly stating his opinion there. This would have given Carol Cutting the opportunity to seek care elsewhere and have one less medical procedure done. The Tourette Association of America has indicated that it's often difficult to pursue legal action because it's hard to show that someone has been limited by one or more major life activities. To me, this highlights a knowledge that there are injustices in healthcare that patients face, but they're hard to successfully defend despite laws being in place to support individuals with disabilities. In closing, Cutting versus Down East is a multifaceted case that's still in progress in the state of Maine. The informed consent portion of the case was not ruled on in federal courts. This case covers many concepts covered in class, including medical malpractice and informed consent. Parallels can be drawn from the cases that we reviewed throughout the class. Thank you for taking the time to view this presentation, and if you have any questions, please don't hesitate to reach out. And here are the references. in case you have any questions about information that was covered. Thank you.